I guess maybe we should shift now to talk about the litigation that ultimately is sort of what Radnor will be remembered for. A creditors committee was appointed, and as we often see nowadays with first lien and second lien and sometimes third lien debt, the creditors committee was totally out of the money. There was a sale going on, and it was going to be to a secured creditor in a credit bid, and the committee had already seen that Lehman had run a sale process and there was nobody else out there, so they knew they weren't going to get anything. And so in those circumstances, the committee was left with one thing to do: hold their hand out and get Tennenbaum to give them a payoff. Well, Tennenbaum was unwilling to do that, and so the creditors committee filed a lawsuit. And they threw everything into this lawsuit they possibly could, including the kitchen sink. They asked that the loans be recharacterized, that the loans be equitably subordinated. They claimed that Tennenbaum, as a preferred stockholder, had breached its duties of care and loyalty. They claimed that the board member, which was Jose, had personally violated his duties of care and loyalty. And they said that this was all part of a scheme when they first made their loans. It was all part of a scheme to own the company when they made these initial loans. And they were never loans. They were always equity investments, and that's what everybody really intended. Their plan was to derail the sale process, to slow it down, and to make as much trouble as possible to get a check from Tennenbaum. You can't credit bid your liens if they're not valid. And so Tennenbaum had a problem. And as part of the sale process, Tennenbaum wanted this all wrapped up. They wanted a release. And the committee said, no way. I filed my complaint. Judge, we've got to litigate this out. Maybe Tennenbaum gets the company in 2 or 3 years, but we'll find out. And Judge Walsh said, well, I've got another idea. How about this litigation happen in conjunction with the sale process? You do expedited discovery, and you have a trial, an 8-day trial, immediately before the sale hearing.
It was all before the bid deadline. He established it all before that time, which is obviously a huge boost to the whole process from a creditor's perspective.
So, and the judge didn't stop there. He said to the committee, by the way, if you don't win this lawsuit, there's going to be no money for your fees, and I want you to know that up front. And so, undaunted, the creditors committee brought their lawsuit. They exercised, they spent a ton of money, over $3 million. They deposed everybody on multiple occasions. They collected documents. Every little email they tried to make a big deal out of. There was an email where an individual who worked for the company, the CFO, sent an email after he found out he was going to be hired by the new company once Tennenbaum took over. He sent an email saying, thanks a lot. And they said, look at this. He's buying off management. That Jose, he's just a bad man. Ultimately, Judge Walsh had an 8-day trial. Jose got to be on the witness stand for 2 entire days, which I can't imagine.
What for one.
And stand for one. I can't imagine what questions they could have asked unless they talked really slow or asked the same questions over and over. It baffles me. I wasn't involved in the case, so I can't tell you.
I did both.
Ultimately, Judge Walsh looked at a whole bunch of different things in deciding that the recharacterization claims, the equitable subordination claims, and the breach of fiduciary duty claims were no good. First of all, he said, look, the transaction documents refer to these things as debt, and what we're supposed to look at in recharacterization cases is the intent of the parties, and the intent of the parties was that they be debt. It's in the documents. In all the emails and documents that were discovered that went back and forth, the parties consistently referred to these as loans and indebtedness. The debt instruments contained a firm maturity date. It wasn't a loan that never had to be paid back. The lender was given the right to enforce the payment of principal and interest, just like you would have in a regular loan. There were no voting rights or equity-type rights or even a board seat as part of the loan transaction. That was as part of the preferred stock transaction. The actual proceeds of the loans were used to pay off other loans and for working capital of the company. The transaction documents, Gave the Tennenbaum folks a security interest, and that was, they'd filed UCCs, and it looked like a security interest. And the judge said, look, just because they made additional loans when the company got in trouble, that's what a prudent lender does. A prudent lender makes loans to protect its situation. That doesn't mean they were making equity investments when they made these additional loans. They were doing it as a lender. The judge found that because there was only one board member out of 4 that was a Tennenbaum person, that having a board seat was not a big deal. He said, lenders have a single board seat from time to time. He noted that Jose resigned as soon as the sale process started, and it looked like Tennenbaum was going to be a bidder. So the judge was not troubled by the fact that he was on the board. He also found that just because an employee of Tennenbaum is on a board doesn't make Tennenbaum itself an insider in any way, that only Jose was an insider, and he'd resigned from the board. And this whole concept that it's somehow an evil task to decide that you're going to credit bid your loans, the judge did not find that to be a reason to equitably subordinate the loans or turn them or recharacterize them from debt to equity. So at the end of the day, the case was a huge victory for secured lenders everywhere, and as a secured lenders lawyer, I personally rejoiced. And the judge was good to his promise. The committee did not get paid their fees. They were out $3 million.
Yeah, they got paid $200,000.
Yeah, they got $200,000 on their $3 million bill. And the sale closed on time, and it got done.